Good morning, all. This ex parte urgent application hearing is in the matter DEC 001-2025 and is being held by way of video conferencing before His Excellency Justice Michael Black, KC, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Altamimi and Company. Lead counsel is Mr. David Holloway. Thank you.
Thank you. And Mr. Holloway, one question first of all, has your client paid in the fortification?
Yes, it has indeed.
Good, I couldn't see that on the court file. Okay, well that's one impediment removed.
I think there was a $15 shortfall with the bank charges, and we Altamimi made that good, but it was done some time ago.
Okay, good. Okay, well, do you want to make your application? If it's helpful, I have read the application notice, which is really in the form of a skeleton.
Yes.
And I've looked at the various references in Mr. Britton's third affidavit. I've not looked at the authorities that you wish to cite. I'm sorry, in the time.
No,
you need to take me to those passages. Obviously, I'm reasonably familiar with the facts.
Well, Your Honour, first of all, thank you very much for sitting at such short notice, and also thank you for doing that reading. I hope I'll be able to make this brief. It's we believe, a short, self-contained point, and the application, as Your Honour knows, revolves around the what's been described as the securitization process, and that was referred to at the previous hearing. And an issue then has arisen out of how that's been taken forward in the interim, and what's being proposed by the respondents that might happen before the return date. Your Honour, I haven't produced a skeleton, and I apologise for that, but it would have only repeated what was in the application notice, with perhaps references to the cases, but I will develop those points.
Yes, I should say, I assume this is all being recorded, and that a transcript of everything that passes today will be served with any order if I choose to make an order.
Yes, Your Honour, I'm not sure whether they are automatically recorded as they used to be. We used to be able to get the video recording immediately after these hearings, but we will be requesting a transcript immediately with the quickest turnaround time available, and we will be making a note as best we can as we go along.
Yes. Well, you again, without in any sense prejudging matters, if an order were to be made, you would want to serve it fairly rapidly. You serve it with a note and an undertaking to serve the transcript as soon as possible.
Yes, we'll do that, Your Honour. The note is being done. We will request the transcript immediately.
Yes.
And I hope I'll be able to
take that as encouraging that I'm with you.
No, I didn't make no assumptions on that whatsoever.
No, I mean, to be frank, the one thing I'm slightly confused about is whether or not, in fact, Aria Dmcc owns the assets at all, or whether it's the Cayman Fund that owns the assets. Because the issue is that the Cayman Fund is not a party to these proceedings.
Yes. And
while Mr. Britton clearly controls everything, Mr. Britton is not a party to these proceedings. So even if I were with you, am I making an order against a party who has no control over the assets?
Well, you'll only be making an order against Aria Dmcc, and its servants, agents, and officers would be bound to obey that order. I note from the reasons about the lack of clarity on the asset position and the ultimate owners of the assets, even on paper, And that is a point that I was trying to stress at the return date hearing, that the evidence on that simply just isn't clear, and that is an area of concern. Perhaps we can come back to that.
Yes, okay.
But I do note that point. I mean, it really is not clear what the relationship between all these entities is. That's something we've been pushing for from the outset, and hopefully we'll be able to grapple with it at the return date. We may be making further requests for clarification on that, but
I mean, I've read Mr. Britton's third affidavit, and I mean, it's not for me to drill down, but I assume that when we come back on the return date, you will have analysed what he said.
yes,
and we'll see whether it's right or wrong.
yes, there've been several waves of this information, and what we're trying to do is grapple with each one of them and how they fit together and whether they're coherent and consistent. Unfortunately, the latest wave came in on Friday.
Yes, of course.
We've not quite got to the Thursday night overnight, but that will be, you know, our reply evidence is due on the 2nd of May.
Yes.
And that will be the thrust of it, the deep analysis of that. We can't really take that much further today, of course.
No, no, certainly not. I mean, obviously the situation is complex, but I'm aware that very complex structures are used in investment funds, and perfectly innocently. So at the moment, I can't form any view.
No, of course, not inviting you to do that today. That wouldn't be appropriate. But there is one. This is a self-contained issue. We are concerned at specific passages in the evidence which suggest that at the return date, an irrevocable decisions may have already been taken with those assets, which may prejudice Techteryx. So we're really simply trying to hold the ring until then, and not even necessarily to prevent that, but to prevent it happening without a further order of the court, with the court having been fully apprised of the facts. Because at the minute we really have very little to go on all of these issues.
Mm-hmm. So
I was going to start just by turning up the previous orders. We may not need to do that, but we had the original ex parte proprietary order, and the operative provision was Article 7 or Clause 7. That's page 7. So that prevented any dealing with the specific assets referred to, but also traceable proceeds, substitutes derived from the monies paid in by Techteryx. So it was a proprietary order basically freezing the bank account and the traceable proceeds of those funds. And the next clause, paragraph 17, was the exceptions. And we had the ordinary course of business exception for the Moreva part of the order, but not for the proprietary part. And that's the way things stood at the ex parte hearing. But I think in practical terms, that meant that there was no permissible dealing with either the bank account or any traceable proceeds. And it's important to remember that it's Aria Dmcc who were prohibited from so dealing, but also in the usual way, their servants and agents and so forth. So that was the original order. And then we had the variation on the 17th of March, and that's at page 17. And the operative part is 1C. So that was what happened, really. That was really the upshot of that contested, or semi-contested, perhaps we could say, return date. The exception does not apply. The business use exception and the fact that it wasn't included in the proprietary order was reversed. So what Your Honour did was keep the proprietary order in place, but add a sort of blanket ordinary course of business exception, i.e. They were prepared to deal with assets in the ordinary course of business. That's where we left it on the 17th of March. And Your Honour will remember there were arguments about the trading companies not being able to pay lay cans, the fact that there was a mine that may not be able to operate, and then there was the securitization issue, which was floated at.
But you accepted that when it came to the mines and the bitumen and the shipping, that was ordinary course of business.
Well,
I think what you said was it's the level above that, dealing with the ownership of those assets, which is thought to be restrained.
What I was saying, what I was attempting to say, was that the order strictly prohibited Aria Dmcc from dealing with those assets. In fact, the assets that were referred to at the hearing were not held by Aria Dmcc, they were held by other.
If you talk about servants or agents, I mean, I don't think you have it both ways. I think, as I understood the submission, was rightly or wrongly, that when we're talking about Aria Dmcc dealing with assets, we're talking about the assets being the companies themselves. The level beneath that, the actual trading of the company, is either not caught by the injunction or is the normal course of business. But either way, I think you accepted that the injunction would not prevent deliveries of bitumen, for example.
Well, we were saying that on the face of it, the order didn't cover dealing in assets owned by other entities that weren't Aria Dmcc. And the second point really was that we didn't really have enough evidence to work out what the connection between all those companies was. So what I was really submitting was that this application to vary the order just didn't have any evidence behind it explaining what the relationships were and why the order prohibited trading companies who were not the named party from trading. Remember, there wasn't actually an application made. This was all evidence that was put in the day before and then submission made. What I was submitting was that they hadn't clearly established either any hardship with evidence or the connections between the ownership structures of the entities who were apparently prejudiced and Aria Dmcc. It wasn't going any wider than that. I certainly wasn't conceding that Techteryx don't have claims against those wider assets that have been dispersed, if you like, because what emerged at the return date was actually that there were no real other investors in the fund, and that's
well, that's something I want to pick up too, because that's really been amplified by Mr. Britton's third affidavit. So we now know that FDT holds 83 point something 23% I think, of the shares in the fund, and Legacy owns 17.77% of the shares. I think Mr. Britton concedes that the 82.23 is directly referable to the 6 remittances, or what does he call them? The DMCC payments, I think. So that leaves the other 17.77. Now, I did note that in 2020, Legacy had invested something around $100 million in the fund. And that money was TrueCoin money as well, wasn't it?
Yes. Yes.
So it is, it seems to me that all of the money.
Well, that seems to be the picture that's emerged, yes.
All of the money in the fund has come from TrueCoin, one way or another, either via Legacy or via FDT. Now, can you clarify for me, because I really haven't, again, had time to track this through the Hong Kong proceedings, but in the Hong Kong proceedings, are they claiming that there is a constructive trust or whatever, not only over the 6 remittances, but also over the earlier payment made by Legacy?
I will have to double check the proceedings against Legacy. I can't offhand, I'm afraid.
Well, I see the Hong Kong lawyers are on the line, so no doubt they can send you a WhatsApp.
Take instructions on that, indeed, as we speak. Might take a few minutes.
That's okay.
Express purpose trust. If I could go off camera for one.
Yes, of course. Yeah.
Your Honour, that might help. I think we may need a little more time to discuss this with them. Your Honour, I'm not putting a quick, clear answer on that question.
Okay, all right. But one thing that is clear is whether or not that 100 million is being pursued in the Hong Kong proceedings. By the look of it, as presently advised, it does look like that all the money within Aria Fund to Cayman came from TrueCoin.
That does seem to be even what they're saying as well. And that, you know, certainly no question that we would then concede that we wouldn't have claims against those assets wherever they have ultimately been sent. Yes, I mean, we would be pursuing those claims against the assets. That is the point of this. We will want to be following those assets.
So when you say those assets, what do I'm specifically at the moment? I mean, I understand the case entirely in relation to the 6 remittances. So the 456 million, fine. Mr. Britton says, well, actually, you already redeemed part of it. There's only 400 million of that for redemption. And that's FDT. I'm just trying to isolate the Legacy shareholding, 17.77%, the derivation of that, which seems to be the payments in 2020, and whether those and whether there is a remedy sought in relation to that or not.
Well, the answer I'm getting is yes, and it is a remedy based on trust claims.
Okay, so there's the same constructive trust argument in relation to the original $100 million
I mean, I'm told yes by WhatsApp. I'd be comfortable
Okay, well, those
myself
are your
checking
instructions.
those pleadings, but
Well, look, those are your instructions from your principals in Hong Kong. That's fine.
yes, indeed. So then,
If they're wrong, we will find out at the.
if they're wrong, I'll correct you immediately. Correct it immediately.
Yeah.
Of course. And therefore, the upshot of it is that the injunction was maintained on a proprietary basis. My position at the last hearing was really that the evidence wasn't clear enough to justify a variation of the order, and the variation they were seeking was to remove the proprietary bit and insert the course of business exception. Yeah. I'm not here to re-argue that, of course, and I think the solution that Your Honour came up with was somewhat of a compromise based on the material. So you kept the proprietary claim in place, but you added the business use exception, and that's where we are. So I think the submissions I'm going to make are based on the position as it is.
Yeah.
I mean, and we can go through the transcript, and I'll try to show you that, of course, I was not accepting that this securitization process could just happen without any.
I'm not. I don't think I'm in a position today to say, certainly not on an ex parte application, to say one way or the other.
Of course.
Whether I consider the securitization is in the normal course of business.
Yes, I
have no intention. I have no intention of reaching any conclusion on that.
Well, I'll make submissions on it briefly, but I'm not here to try and obtain a binding and final determination on any of these issues. It is simply.
No, it seems to me that the proper basis to proceed today is that the securitization may be in the normal course of business and may fall within the exception, but actions within the normal course of business may nevertheless give an indication of a risk of dissipation. And I think what you have to do is to persuade me that the proposed securitization occurring as it is said before the next return date is evidence of a risk of dissipation and therefore ought to be restrained. I mean, that's the thrust of your application, I think, isn't
it? Yes, I mean, I'd go a bit further and say that it has to be permitted by the order. It would have to be an ordinary course of business transaction, number one. And even if it were an ordinary course of business transaction, it might still contravene. It may be if it could be seen to be an improper transaction, or an attempt.
That's what I'm. I don't think the first stage of that argument is something that I can address today. Only the second stage may perhaps on the assumption that it is in the normal course of business, but nevertheless, does it give rise to a proper apprehension of a risk of dissipation and should be restrained?
I'd rather expected it to put it the other way around, that it plainly isn't an ordinary course of business transaction.
Well, I'm not. I tell you, I'm not minded to address that issue. I think it's too complicated to address on an ex parte.
Well, I'll gently try to take you through the authorities on that, because I think I would have expected the other limb of it to be something that would need to be fully thrashed out at the return date as to the ultimate purpose.
Ultimately, it has to be thrashed out on a return day. But the other limb the other limb may actually be a lot more straightforward one way or the other.
Okay, well, I'll see where I get to.
See where you get
both
to.
of the limbs, yeah. But first, just to sort of frame it, the securitization process was first referred to in Mr. Britton's first affidavit, and he said that there was a process being carried on. It might take 6 weeks, but that was really it. I mean, I can give you the page and para references to that if you like.
I mean, I've worked on the basis of my reasons, and I reread my reasons, and I address the evidence on that.
But I mean, the only point is that in that first affidavit, which is what you had at the return date, the only real evidence about it, the only sort of document that was exhibited is this one, which was the presentation.
Yes. I spoke about that in my reasons.
And that's, with respect, it's a 2-year-old PowerPoint presentation that doesn't really give any concrete information about what's being proposed at all, apart from a very general sort of idea that that this could be a way of changing Aria DMCC's business.
But it wasn't. That presentation was not directed towards any form of redemption.
No, it didn't seem to be. It seemed to be much more generic than that in terms of a sort of general business structuring proposal. And then, so we have very, very little to go on at that point. And then we don't really have anything further to go on this time, because I'll take you to those paragraphs now. They're at page 72 and your honour's read them. We've got paragraph 106 to 110 and no supporting documentation at all. So no correspondence, no detail as to what's being proposed. So that's one point. But I think your honour can see, I think that, in general terms, they've engaged an agent to prepare documentation. They say that they will be giving information to that agent shortly. But paragraph 109, I think, is the one that has prompted the application. The assets held by the fund will be sold to the securitization vehicle Luxembourg entity this month, and in consideration of that, bonds will be issued to the fund. Now that we don't know when that could be. I mean, a binding sale agreement could be concluded today, tomorrow. It could even have been concluded yesterday. And then the next paragraph, a significant portion will be completed before the return date hearing. And this, something that's been floated for 2 years, it's all now being done, proposed to be done, before we come back to the return date. So what's really being proposed is that at the return date on the 12th of May, Aria DMCC and Aria will say we don't have any more of the assets. We've got a bond from a Luxembourg entity, and potentially that really has an impact on the proprietary order that we have. And then just one more paragraph, paragraph 151. Which, yes, is under the heading no dissipation of assets. Paragraph 151 says that what's proposed is actually that all assets, well, first it's quite interesting because it says Aria DMCC is no longer in control of the assets purchased with the payments, and those assets have already been transferred to the fund or will be so transferred as a result of the securitization, and that's really the nub of it. That at the return date, it will be said that those assets can no longer, or the order just cannot be policed or is outside the scope of the court's jurisdiction. And that's really, I think, the crux of why we're here today. Now, that yeah, so the future tense of that, we don't know when, but that's the crux of it. In terms of whether this is a transaction in the ordinary course of business, Your Honour, if we think back to the return date, much of the emphasis was on the urgent need of companies to be able to trade, i.e. pay their debts, buy things, sell things, etc. But a complete securitization of hundreds of millions of dollars of assets and putting them outside the control of the party to this litigation, in my submission, it cannot be said to be an ordinary course of business transaction. This is an exceptional transaction by any view, and an unusual transaction, and not least because we just don't know anything about it. And there are, I think, the cases that I cited, I think, to just make this point, that it doesn't necessarily mean that if a transaction is not ordinary, that doesn't necessarily mean that it's nefarious or done with a view to dissipate assets. That's obviously something that needs to be analysed in detail. But is it an ordinary transaction? Is this a run-of-the-mill business transaction? In my submission, it plainly isn't. And it's not that means that it will always be prohibited by the court. But what it does mean is if you're going to do a transaction like that, when a freezing order is in place, you are required to come to the court and explain it. And what they've done is they haven't done that at all. They've sort of slipped it in to the analysis in a very general way at that return date hearing, and then taken the fact that the course of business exception was put in as a sort of carte blanche to do the most extraordinary, concerning things. So I will take you to the cases if that would help.
That will help. Yes.
So I think the clearest one is Abriazov, the Court of Appeal decision, and that's tab 10 on page 94. And that was Mr. Abriazov, obviously subject to freezing orders, and he conducted a restructuring of his assets without reference to the court, and then afterwards applied for a declaration that the transactions were ordinary course of business transactions and should be blessed by the court. And the Court of Appeal made it clear that I mean, ultimately they said, well, it may be a technical breach, but you can't do that. You have to, in a transaction like this, come to the court first and get permission to do it. I think if I can turn you to paragraph 74, I think that's the relevant passage.
What page is that?
It's at page 111, Your Honour. And I think the point I'd rely on is at the end, but it may be worth just to read the paragraph.
Okay. Let me read it to myself.
Thanks.
Yes, of course. You rely on the
last sentence, really.
beginning dealings or disposals.
Yes, and then the last sentence, those kinds of transactions which may or may not be dissipatory, but are certainly not ordinary. They merely require the approval of the court or the claimant before they're carried out, to enable the court to scrutinise what on its face may not be a routine or regular transaction. And that's the test. Is this a routine transaction?
Where are you reading from?
The very last sentence of paragraph 74.
They merely require approval report to enable the court to scrutiny. Yes, I've got it. Yeah.
And then I think just very quickly, the paragraph 75, the judge below, Nigel Tier, or Mr. Justice Tier, had felt that the ordinary course of business should be given a wide meaning, and the Court of Appeal disagreed because, just sort of 4 or 5 lines down, we think that's too widely stated. Literally applied, it would entitle any defendant to dispose of or deal with his investments free of the scrutiny of the court, and it's inconsistent with the structure of the freezing order. And then skipping to paragraph 76.
Sorry, may I just...
Oh, yeah, sorry, Your Honour.
Yeah.
Then just moving on to paragraph 76, this is the last one I'd like Your Honour to look at, but this format points, in our view, to the standard exception being given a narrower rather than a wide meaning. Transactions of a trading company will include its purchases and disposals, trade and liabilities as they fall due. A regulated investment company that sells shares and securities would be treated in the same way, i.e. selling and buying securities, but we don't consider it would comprehend the alteration of investment by an investor, however wealthy he would be. So I just...
Okay, I mean, the other side will argue that they are an investment company, which requires a sell share.
Yes, but they're not buying and selling. I mean, are they an investment company? Aria Dmcc, we can go back to their trade license. It's a commodities trading company, but in any event, getting rid of all their assets in one go in this way. I'm not saying it's necessarily nefarious. I'm saying it's not routine. It's not run of the mill. It's an unusual transaction. And I'm not today seeking an order, making any declarations about whether this is or isn't in the ordinary course of business, Your Honour. They may be able to persuade you that it is. What I'm simply saying is it's the kind of transaction that ought to be blessed or scrutinised by the court in the context when the defendant is subject to a proprietary freezing order before it is permitted to proceed. And it's concerning to us that this all needs to be done before the return date hearing. If there is urgency, that is something that obviously that they would have liberty to apply on. Just to make a couple of quick points on the other cases, but they all refer to that case and that reasoning. The But if I can just go to the other Court of Appeal one, which is organic grape.
Yeah.
That's it starts at page 1.
Yeah.
Starts at page 114. I'll just take you to 2 paragraphs of that. That's Lord Justice Newey. The first one, paragraph 15, may be somewhat trite, but the court will not restrain. This passage summarises the ordinary course of business exception, but it stresses here not restrain all conduct. But I think the key point here is absent a proprietary claim. A defendant's assets belong to him and a freezing order is not intended to give security. Well, we still have a proprietary order here, so there is a slight difference. Even from these cases that I'm citing to you, these are all Mareva cases. In a proprietary situation.
Of a proprietary.
Ablazov?
Yes.
Don't believe it was, but let me. Well, there was a proprietary claim in the case, it's true, but whether the order was made on a proprietary basis, I don't know.
Okay.
It is a relevant consideration, though, I'd say, but we are still interpreting the course of business exception, which is part of the order. And then the other paragraph.
Sorry, yeah, so we're looking at paragraph 15
Yes.
Organic grape. So you rely on the sentence, absent of proprietary claim, defendant's assets belong to him. Okay.
It's simply just to bear in mind that if these assets are all being sold to a Luxembourg entity, it's not necessarily the case that these are Aria DMCC or Aria fund assets. It's still arguably the case that my client has proprietary interest in those assets. And then paragraph 20. So just simply that, I mean, the original wording for this, as your Honour knows, was ordinary and proper course of business, and that was the original standard form wording, and it had to be both. So it's not the case that all ordinary transactions are proper and not all proper transactions are ordinary. The order has to prevent against dissipation, but actually the ordinary part of the wording simply means what I've just tried to submit to you, that's talking about run-of-the-mill transactions and so on and so forth. That point's made in the other authority as well, State Bank of India and Malaya. They do refer backwards to both the cases that I've cited to you. I would probably just point your Honour to paragraph 11.
Let's have a quick look. I don't think it adds anything.
Well, just
transactions that are one-off or not ordinary require
yes.
scrutiny from the court.
Yes, exactly. And that's that really. Those were the points on that. So
Hold on. Okay.
So I would submit there is a strong argument that this is not an ordinary transaction, but I'm not asking you to finally determine that. The other side may well be able to persuade all of us that that this proposed transaction is perfectly proper, but they haven't put any evidence or detail in. And what I'm asking is that this shouldn't be done without that process being gone through, and certainly not before the return date. That's the looks of it.
Mm-hmm.
And then I should take you to their letter in response to what we asked for on Friday. Sorry, I could take you to our letter first, page 87. We made the points. We didn't think it was in the ordinary course of business. We were concerned that it meant that the assets would be dissipated before the return date, and we asked for two things. We asked in paragraph 5 for just an undertaking that this would be ceased until the return date hearing. And we asked at paragraph 8
Mm-hmm.
for the supporting documents, including correspondence with the securitization referred to in Mr. Britton's third affidavit, so that we could have an idea of what was actually happening. The reply came swiftly on Friday, page 89. They declined to give the undertaking and just didn't respond to the request for information at all. I can take you through the reasons that they gave in their letter, should take you through those.
Okay.
Just very briefly, paragraph 7, which is
page 89. Yeah.
page 90, that will be then.
Mm-hmm.
Paragraph 7, they say the order does not prevent the securitization process from progressing, subject to legal and regulatory compliance. Paragraph 6, I think they say, well, your reasons didn't expressly include.
Yes, you referred to all of this in what I take for your skeleton.
Yes. Yeah. So they say you didn't expressly deal with it, but that was because we accepted that the securitization process should proceed. And I should stress that neither I nor my clients ever accepted that this process should be concluded, not least because they have no real information about what it is going to be. And that's a point that, Your Honour, you did pick up in the reasons. Or in the transcript, I think Your Honour mentioned it would depend on the terms, it would depend on the paper, whether it was investment quality paper, whether it could be traded, and so on and so forth. I can take you to those, and we can go through the transcript. I have.
Yes, that would be. Yeah, can you take?
Yeah, I think we should. So there were very, very little discussion of this in the transcript, but the first reference is Mr. Montague Smith referring to it at page 216 of the bundle, which is, I think, the bottom of page 88 of the transcript.
Yeah.
So he, I think, says that paragraph, the last paragraph of his submission, he says, okay, there was a KYC issue, it couldn't redeem because of this alleged KYC issue, and that's why they're trying to securitize and redeem the notes. That's ongoing, and that you then, Your Honour, commented. No, sorry. It's at the same page, I think, at the bottom. Yes, page 89. You commented. I can see issues with that. Obviously, it depends on whether the bonds issued are investment grade, whether there's a market for them, etc. And Mr. Montague-Smith says, well, we're allowed to redeem in kind under the PPM, and that's really it. He then says, sorry, Mr. Montague-Smith then says, redeeming in kind avoids problems, alleged problems with redeeming in cash. And then, Your Honour, you make the point at the bottom of page 217 that it's not a problem for me, you say, and not a problem certainly for today. And what I took from that, and what I still take from that, is that the ins and outs of the securitization process, we just weren't dealing with that at the last hearing. There wasn't any evidence on it. There wasn't any concrete evidence on it. It was floated along with a number of points, but that exchange is the first reference to it, and that was the only reference to it in Mr. Montague-Smith's opening position. And then my submissions on that at page 252, again, very, very brief. I think the sort of first full paragraph, that I say I'm not going to spend too much time on that. I'm instructed that this has been promised before. Really, there's no evidence that the order has impacted it. There's no evidence that he's been prevented from presenting a securitization process. And then the concluding line, we just don't have any reliable evidence of any plan that could reasonably accept it to give security to Techteryx. So my submissions are looking at it from the fact that we have a claim against them, and we have a freezing order against them. Whatever is being proposed, and we don't have any concrete, we would have to look at that to see whether it actually helped us or not. It certainly wasn't accepting that the plan should just carry on and be concluded. Then the point that you made, Your Honour, I made throughout that page a long submission based on the fact that there just wasn't any evidence of the financial hardship caused to the entities that Mr. Montague-Smith said there was, and we didn't have concrete evidence of it.
Yeah, it's a different issue.
Yeah, and no evidence of the sort of relationships between the entities that were alleged to hold the assets and so on. And then I think at page 133, I make more submissions.
Sorry, one.
Oh, that's 260 of the bundle, pardon me again. This submission is really about the balance of convenience. So I'm saying, given that this is a proprietary claim and that we're the only people who seem to have an interest in the fund, it's obvious that the balance of convenience tilts in our favour. And then I talk about there's no evidence that they own the bitumen plant. There's no credible evidence.
Is another issue, isn't it?
Yeah. Yes. But and I repeat that submission about the evidence. So that's the sum total of it. Then in reply, Mr. Montague-Smith did talk more about securitization, and I think it's 262, and he says, sorry,
It's not 262.
He says trying to find the bit where he says my submissions are extraordinary. Yes, sorry, it's 276. No, that's not it. That's extraordinary. He says it a lot, actually. I'm trying to find this bit. No. 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 Yes, this one. It's page 283. Pardon me.
283.
He said, my learned friend submission are extraordinary. He says, what does securitization have to do with it? And he says, you know, my point that we were looking for security for the claim and the injunction, he said that's irrelevant. Securitization is a completely different process. It's about converting a business into securities. And then further,
we will see a securitization note. I thought I'd not seen it.
it's to do with the Gloppert and Kearson shipping companies and the purchase of those for 42 million.
I think I'd like to have a look at it.
Well, where are we?
That's all right. I have access to.
You have it. I have it as well. 2018.
No. I will find 2018. I can find it quite quickly, I think.
Yes, so that I think he's saying that the process started and
it's just this statement, it's not a note.
yes, and you see that
Sorry, let me just get it up on the court file. So file 2018, you say?
yes.
2.
Oh, is it 2108?
2108, yes, I think.
2108. Yes.
It's just loading.
One of those documents that's been turned around.
Okay, that's not fabulously helpful. I need to go to the PDF to switch it around. Sorry, you'll have to bear with me again. Let's take 125. Where's the previous? 2. Okay. Anyway, right. Detailed positions of portfolio. At the bottom, it says structured product. Is that
Yes. Yes, that's it. That's the reference.
21 million? Okay. And what is that said to be?
So
That is an exhibit to this second.
yes, it's the exhibit to the second statement, I believe.
Yes, a witness. That's a witness statement of the affidavit.
Yes.
Election. So let's just have a look at that.
I'll go back to that. Yes.
That's it. So it's page 248 of his exhibits. second witness?
I'm trying to find it as well.
Okay. And search for 248. Okay.
The I think it's 2395, this statement.
I've got his statement. I'm just trying to find the reference to. I've got the statement. I'm just trying to reference to Exhibit 248 in that statement. Bear with me. See if I can scan through it. I just want to know what he says that is.
Yes.
It's the statement starting at 1840 for you, but he already knows what that is.
That's 1840 is the affidavit. I
Yeah,
think
but that's what MWT is.
That's what I have that here.
Oh,
So it's
MW. He's talking about MW's. Well, what's the exhibit to this? Maybe it's not an exhibit to this. Let's have a look.
it's an exhibit to his first.
What is
It's the exhibit, I think, to his first affidavit. I think.
I think it's his first affidavit. Yes, I think that's right.
Sorry.
Let's go to his first affidavit.
Yes, that's right. And I think that securitization may be dealt with around paragraph 43.
Well, let me just get my hands on his first affidavit. First affidavit, there we go. I'm sorry, what did you say, paragraph?
Well, I know that section D6 at paragraphs 43 to 50 talks about securitization, and
Yeah, let's see if I can just whiz through quickly and find the page number.
the exhibit bit. It's the exhibit, it's page 1.
That's right.
To
2102, right.
So let's just try and find that.
It's talked about in his second affidavit.
I can't immediately, but I may have missed it.
Can't find the reference to the exhibit in the statement either.
Well, let me do first. So the first affidavit. Let's make sure. Right, exhibit. WP2 is the exhibit to this affidavit.
It is.
So let's just see if there's reference within this affidavit to page 248 of that exhibit.
I can't find a reference, having just quickly read it, but
Well, I'm doing a word search.
Doesn't work because their documents not OCR.
I mean, I'll look at it.
It's in affidavit 2, which is in none of the bundles so far. But what does it say? This is part of the securitization, and I think it relates to the vessels that were been transferred to used as work pen and loans issued back.
Right.
Structure. So it is a structured product, but it doesn't appear to have anything to do with. I don't even know who. Details positions of portfolio, EFG. No idea what this refers to.
Yeah, I'm told, and I remember that more is said about this in the latest affidavit. The second affidavit.
Second.
That's yes. So he talks a little bit about it in his second affidavit, but I don't think doesn't exhibit.
So where is that? Where do I find
that? I believe is not yet in any bundle. Sorry, we can send it over now.
I've got this. That's okay. I've got the second affidavit here. Okay, just tell me where it is in the second.
Paragraph 40.
Paragraph 40. Just getting there. Paragraph 40.
It's talking about the accounts.
It's talking about the asset disclosure statement.
Oh, right. Yes. Yeah.
It's those items.
So
Yeah. This is talking about the asset list. This is verifying the asset list and
yeah.
commenting on it. And we think that relates back to that document somehow.
But what goes back? 2 entries for the value of bonds issued against the 3 vessels previously purchased. Subsequently.
And then paragraph 40 and 41. So there are bonds listed as assets.
But those are not bonds issued by the fund.
Yes.
Those are bonds which are held as assets by a company.
Believe they may have been bonds issued to the fund in relation to assets that were transferred somehow. And I think Mr. Britton's saying that that is evidence of some securitization that has already happened.
But all I see there is 21 million.
Yes.
AAFS securitization SA. So the issue, that's the issuer, presumably.
Yes.
And it's a tracker.
Yeah.
On low pet capital. I don't understand what that really means. There's nothing to, it's not securitization of any of the assets.
I think Mr. Montague-Smith described it as a securitization note, and it's sort
well, it
is.
Of course it is, but it's got nothing to do. It doesn't appear to have the slightest thing to do with the securitization of the assets of Aria fund in order to allow redemption, does it? On the face of it, without some detailed explanation.
Yes, and it seems to predate all that as well. It's where's the
September 20.
yeah where's
last line of the page.
oh yes, sorry, the note itself, last AC September 2021. This securitization process.
Where are you reading from?
Sorry, when you look at the actual statement on page 2108, and it says USD 21 million, then there's a bold heading. The final line, the third line,
acquisition, acquisition September 21. So it's nothing to do. It is.
Well, yes, I mean,
the bond acquired in September 21.
I mean, we really are guessing a little bit to some extent here, but the process as he described it in his first and third affidavit began with a PowerPoint presentation in May 2023. So this doesn't seem to be connected to that, but we're piecing together.
But the submission that was made to me by Mr. Montague Smith, page 283 of the transcript, page 283 of that, yes, of that bundle. It's ambiguous. The letter of print submissions are extraordinary. He says, what does securitization have to do with it? First, there is a securitization note. You will see a securitization note in the bundle, 42 million. I can't tell you precisely which accounts that relates to. But this has absolutely nothing to do. Let's just read the context of it. Yeah.
So again, he's.
I'm sorry, let me just read what he says.
Yes, indeed. And that's 2024, isn't it? I mean, yeah, correct.
But that page of the exhibit has absolutely nothing to do with redemption.
Yeah, I mean, these submissions were made in reply. I didn't have the benefit of decoding it, and we will be, of course, drilling into this in some detail in our next submissions. But the process that he talks about started in 2023 with this PowerPoint presentation. What Mr. Montague Smith's talking about, you know, when he says Techteryx came on the scene, that was 2024. And then Mr. Britton says that, I think paragraph 41 of that second affidavit, that those bonds that you were looking at were delivered to the fund as part of the securitization proceedings, which I've described in paragraph 49A, even though the date is 3 years before. It's yeah, those are the only pieces of paper you've got to work on.
Yes.
The PowerPoint presentation and that statement of bonds. So I think Your Honour said the evidence.
The PowerPoint was in
May 2023.
And the bonds were purchased in 21.
Ah, yes, yes. It seems to suggest that document. We've got one piece of paper to go on.
Yes, okay.
Just one other point. There is another reference to that in the third affidavit, which came in on Friday, just for completeness.
Yes, so let's, right, that's easier.
That's at page 71, paragraph 99, paragraph 98.
Asset holder.
And
it just happens that it's an asset.
yeah. And he says at paragraph 101, I produced evidence of the fund's holding of securitization notes issued by those companies, and so on and so forth.
It has nothing to do with redemption.
But even if it did, I'll submit we've gone beyond that point. This isn't a kind of commercial discussion about how best to redeem these investments. This is a fraud claim with a proprietary freezing order attached to it, and the idea that we can come up with more pieces of paper and divest of whatever assets we say we have. That, I mean, Your Honour, you said in your reasons some of this evidence raises more questions than it answers. Just in that context, we do feel the need for some policing of this order, and I've tried to request it to the most, conscious of it being an ex parte order, to the most limited way we can.
Okay.
I didn't really have anything else to say, to Your Honour,
Okay.
unless you have any further questions.
No, I don't. I make it 11:17 now. I'm going to deliver an oral judgment. I think I can get it done by 12:30.
Your Honour, we're in your hands. I'm very grateful. I did. Sorry, we had two practical questions. I'm sorry to trouble Your Honour again, but I think we agreed with the registrar to file an affidavit if necessary, because we have.
You will have to you'll have to whatever happens, you will have to file an affidavit verifying this. I mean, if you it should verify clear. Well, I mean, what was said in the application note is under a statement of truth, but I would prefer if that were verified by the client, yes, rather than by one of the legal team. And clearly, anything that you said to me this morning must also be verified on affidavit by the client.
Okay.
Whether I'm with you or against you.
Yes. Okay. And then. Okay. Yes, that's all I had to say. You're right.
Okay.
Thank you.
Well, let me see if I can get all of this done by 12:30. Assume that we are coming back online at 12:30. If I've not finished, the registry will tell you and give you another time.
In your hands, John. Thank you.
Okay. Thank you very much.
Okay.
Good afternoon. Can you hear me okay?
I can indeed. John, can you hear me?
Yes, I can. Right. I shall give my judgment now. In the interest of time, I'm giving an extempore oral judgment. I reserve the right to make editorial corrections when I see the transcript. This judgment is to be read with the reasons given on 24th March 2025 for my order made on the 18th of March. On 11th April, that is to say after court hours on the 10th of April, the first respondent, Aria Dmcc, served a third affidavit of Mr. Britton, sworn on 10th April, pursuant to my order of the 18th of March. The claimant now alleges that paragraphs 106 to 110 of the affidavit set out various steps which Mr. Britton says have been taken in relation to a purported securitization and proposed next steps in relation to it. These include: 1, the assets allegedly held by the Aria Fund, including its alleged interest in Tasmanian mining assets and coal reserves, will be sold to an unnamed securitization vehicle, open brackets, a Luxembourg entity, close brackets. 2, the sale will be completed, quotes, this month, close quotes, in consideration certain unspecified bonds will be issued to the fund, which Mr. Britton says will take a further 14 days. And 3, Mr. Britton expects that a significant proportion of the securitization will be completed before the return date hearing, now listed for 12th May 2025. The claimant says that no supporting documentation was exhibited. It claims that these matters are of serious concern to the claimant because what seems to be proposed as the dissipation of the alleged remaining assets prior to the return date hearing in contravention of my order of the 18th of March. By letter dated 11th April 2025, the claimant wrote to the first respondent setting out its concerns and requiring its representatives to confirm by way of formal undertaking by 1700 GST on the same day that no further steps will be taken in relation to the securitization prior to the return date hearing. The claimant also requested, quote, please confirm what steps have been taken since the making of the order in relation to the proposed open inverted commas securitization, close inverted commas, and the details of its proposed terms. Please also provide any supporting documentation, including the correspondence with the securitization agent referred to in Britain 3, and which evidences the steps which have been taken and the proposed terms of the open inverted commas securitization, close inverted commas, end quote. By letter dated 11th April received at 17:05 GST, the first respondent declined to provide the requested undertaking and stated, quote, the reasons also acknowledge that our client sought an amendment to the order on the basis that it would prevent our client from taking any further steps to implement the securitization process, and significantly delay in that process could cause the scheme to be abandoned so that securitization is no longer a viable means of realizing the value of the relevant assets, open brackets, paragraph 47, open brackets, little f, close brackets, close brackets. Next paragraph, still part of the quote. The amendment to paragraph 17, open brackets, 1, close brackets, of the order was granted on this basis. The judge did not expressly address whether the securitization process could be carried out in the ordinary course of business because it was not in dispute at the hearing as a result of Techteryx's own submission that the securitization process could progress under the order. Next paragraph, still part of the quote. Our client's position is that the order, brackets, as amended, close brackets, does not prevent the securitization process from progressing so that the fund can be in a position to redeem the existing subscriptions subject to legal and regulatory compliance, end quote. Paragraph 7, brackets, little f, close brackets, of my reasons does record that Mr. Britton did say that, open quote, without amendment, paragraph 7 of the WFO will prevent Aria Dmcc from taking any further steps to implement the securitization. The effect of significant delay in that process is unpredictable. However, there is a possibility it will cause the scheme to be abandoned altogether by the participating parties, especially if the value of the underlying assets plummets, so that securitization no longer represents a viable means of realizing value of those assets. Close quote. It is right that while I allowed Aria Dmcc to deal with assets in the ordinary course of business, I was not invited, nor did I express a view as to whether the securitization process could be regarded as such. The claimant says that the first respondent did not engage with the claimant's request for further information in relation to the proposed securitization and did not provide any documentation as requested. In the light of what is said in Mr. Britton's third affidavit, together with the response of the first respondent on 11th April 2025, the claimant now seeks urgent relief for the following 10 reasons. 1, the proposal set out in the third affidavit will involve significant and substantial unjustified dealings with and dissipation of assets within the scope of and contrary to the order in advance of the return date hearing. Contrary to what the first defendant now suggests, the claimant has never accepted the first defendant's proposals in relation to securitization and has never accepted that this was or should be permitted by the court. 2, as Mr. Britton states in paragraph 151 of the affidavit, the effect of the proposed transfers will be to take those assets out of the control of Aria Dmcc and outside the protection of the court. 3, the proposed securitization cannot be justified by the ordinary course of business exception as asserted by the first respondent. The claimant has not accepted, does not accept that the proposed securitization is within the ordinary course of business exception. In any event, the first respondent is not in a position to satisfy the court that such steps are within the exception, given that no documentation was accompanying those paragraphs of Britain 3, and inadequate information has been provided in relation to the proposed securitization. 4, before concluding a transaction of this nature and magnitude, the first respondent ought to have set out its proposals in detail in advance, and in circumstances where the transaction is contentious, should have applied to the court for a declaration that the transaction is permitted by the order as amended. 5, the first respondent has not done so. Instead, it summarily stated its intention to carry out the proposed securitization without providing any supporting documentation or explanation. It has refused the claimant's requests not to take steps pending the return date hearing. 6, in addition to the total lack of evidence as to the nature of the transaction, no good reason has been given as to why it needs to be completed before the return date hearing and without reference to the court. 7, given the order was made and was continued on a proprietary basis, the claimant ought to have the right to have the purported securitization subjected to proper court scrutiny. Any further steps taken by the first defendant, including the conclusion of binding agreements in relation to its assets, may amount to irrevocable dissipation, depriving the claimant of the protection of the court. 8, the claimant seeks an order to hold the position until the return date hearing. The order sought is in limited form, namely to prevent further steps being taken in relation to the securitization before the return date hearing without the permission of the court. 9, the first defendant will have liberty to apply to the court before the return date hearing. It is of the view that securitization needs to be completed urgently before then and is properly permitted by the court, and is properly permitted by the order, brackets as varied, close brackets. 10, the order is sought on an urgent ex parte basis because there is a risk that were notice to be given, this would defeat the purpose of the order sought in the application. The first defendant has made it clear that it is proceeding with securitization, including by transferring assets shortly without further reference to the court. The first defendant has also stated, brackets, in the claimant's view wrongly, close brackets, that it considers it can do so in compliance with the existing order. In oral submissions to me, Mr. Holloway emphasized that notwithstanding 3 affidavits sworn by Mr. Britton and a witness statement, there is no information to clarify the ownership structure of the various trading entities. There is in particular no information whether, and if so when, Aria Dmcc transferred ownership of those entities to Aria Fund. Mr. Britton says that a securitization agent, capital A, capital A, capital F, capital S, securitization, capital S, capital A, brackets, the quote securitization agent, close brackets, a Luxembourg entity, has been engaged to prepare necessary documentation in order to implement the securitization. The process of collating the relevant information is well underway and will be provided to the securitization agent shortly. Mr. Britton's present expectation is that the assets held by the fund, including its interest in the Tanzanian mining assets and coal reserves represented by the preference shares, will be sold to the securitization vehicle, brackets, a Luxembourg entity, this month. Underline, will be sold to the securitization vehicle, a Luxembourg entity, this month. In consideration for the issue of bonds to the fund to be issued through Euroclear, he anticipates it will take a further 14 days from completion to issue such bonds. The carbon resilience interest will follow once the necessary regulatory approvals have been obtained. Based on the above timetable, Mr. Britton currently expects that a significant proportion of the securitization will be completed by the return date hearing. Once complete, the fund will be in a position to redeem the existing subscriptions by the issue of such bonds, subject to the fund service providers gaining sufficient comfort from a legal and regulatory perspective. Mr. Holloway points out that Mr. Britton has provided no supporting documents, no correspondence, and no detail. It was submitted to me at the first return date hearing on 17th March 2025 that the securitization scheme was a scheme devised by Mr. Britton, the purpose of which was to enable FDT and Legacy, brackets, whom it is alleged misappropriated the claimant's funds in breach of trust and or constitute constructive trustees of the claimant's funds, close brackets, to redeem their investments in the Aria fund. I found that evidence somewhat ambiguous. At paragraph 45 of my reasons, I noted that Mr. Britton referred to a presentation which seemed to be an undated general marketing proposal for Aria Fund to offer securitized notes representing trade finance rather than loaning money directly to third-party borrowers. It did not appear to have anything to do with redeeming the interests of FDT or Legacy. Of course, quotes, redemption, close quotes, may be a misnomer if understood in terms of cash redemption. As Mr. Montague Smith, King's Counsel, pointed out at the hearing on 17th March, the fund is entitled to redeem in kind. The scheme, however, would mean swapping FDT and Legacy's shares in the fund for some sort of undefined debt instrument issued by an unidentified Luxembourg entity. As indicated at the hearing, much will depend on whether the bonds are regarded as investment grade and whether there is a market for them. Given that it was Mr. Britton's evidence that some securitization has already taken place, it would have been simple to have produced that documentation. At the hearing, Mr. Montague Smith did refer to what he called, quotes, a securitizing note, close quotes. In his third affidavit, Mr. Britton explained that there was evidence of the fund's holding of securitization notes issued by Keirstone, K-E-I-R-S-T-N-E, Shipping, and Glopet, capital G-L-O, capital P-E-T. This does not appear to have anything to do with the securitization to enable redemption. It does therefore appear that Mr. Britton chose to withhold evidence of the redemption securitization that has taken place hitherto. One possible inference is that he does not wish to disclose the ownership of the assets alleged to have been purchased with the funds alleged to be the claimants, or that of the coin holders held by the claimant on their behalf, close brackets. If that were the case, it would be strong evidence of a risk of dissipation and by the adding of a further layer or more to the ownership structure of assets into which the claimant seeks to trace. The situation is perhaps exacerbated by the revelation in the third affidavit that FDT and Legacy are the only investors in the fund. This is in itself odd for a fund that claims to be generally traded, but for immediate purposes, it indicates that there is no urgency to complete the securitization before the next return date. Apparently, 82.23% of the shares in the fund are held by FDT and 17.77% by Legacy. Mr. Britton seems to accept that FDT's holding can be attributed to the 6 remittances, and as I noted in my reasons, it does appear that Legacy invested around $100 million of TrueCoin monies in the fund in 2020. Mr. Holloway tells me on instructions that that sum is also sought in the Hong Kong proceedings. It is therefore possible that all the current shareholding in the fund was purchased with monies entirely derived from TrueCoin. If that is so, no person other than those involved in the various proceedings is affected by a delay in the securitization, what is only a matter of 28 days. The hurry to complete the securitization before the next return date in the foregoing circumstances may also be regarded as evidence of a risk of dissipation in that it has no apparent commercial purpose nor affects any third party. Mr. Holloway submits the securitization of the entirety of a fund's holding would not be regarded as being in the ordinary course of business. He described it as, quote, an exceptional and unusual transaction, close quote. In this connection, he referred me to 3 authorities. The first was JSC BTA Bank against Ablyazov, open square brackets 2010, close square brackets, capital EWCA, capital C, little I, little V, 1141, at paragraphs 74 to 75. Quote, but dealings or disposals which were not part of the ordinary course, were not part of the ordinary business of the defendant, in that sense do not necessarily fall foul of the purpose of the freezing order. They merely require the approval of the court or the claimant before they are carried out, so as to enable the court to scrutinize what on its face may not appear to be a routine and regular transaction. Next paragraph. The judge relied on the judgment in Normid, N-O-R-M-I-D, housing as providing support for his view that the paragraph 9 brackets, little b, close brackets, that section should be construed widely and not narrowly. It should, he said, be construed as extending to the activity of holding and managing assets so long as it is not aimed at dissipating a defendant's assets. We think that this is too widely stated. Literally applied, it would entitle any defendant to dispose of or deal with his investments free of scrutiny of the court, and is inconsistent with the form and structure of a freezing order, which, for the reason stated earlier, close, deliberately does not limit the scope of the injunction to transactions carried out with an intention to dissipate. The need to protect a claimant from this risk, open brackets, in a case which by definition must have involved a prior finding by the judge that there is a real risk of dissipation, but for the grant of the injunction, close brackets, achieved by prohibiting all disposal of assets except those permitted by the express exceptions to the order, and by giving the defendant general liberty to apply in respect of any particular intended disposal. Transactions can therefore be sanctioned by the court if found to be unobjectionable, then permitted. C. Atlas Maritime Shipping Co. S.A.V. Avalon Maritime. Next paragraph. The format points, in our view, to the standard exception about disposals in the ordinary course of business being given a narrower rather than wider meaning. Transactions in the ordinary course of business in the case, open brackets, e.g., close brackets, of a trading company will include all its usual purchases and disposals and the payment of its trade and other liabilities as they fall due. A regulated investment company, which acquires and sells shares and other securities on behalf of its clients, will be treated in the same way. End of quotation. Mr. Holloway accepts that the first respondent will contend that the securitization is in the ordinary course of business, even on the narrow construction, although he pointed out that Aria Dmcc is not, in fact, a regulated investment company. The second authority is Organic Grape Spirit Limited, the Nueva IQT, open square brackets, 2020, close square brackets, capital E, capital W, capital C, capital A, capital C, little I, little V, 999, open square brackets, 15, close square brackets. Dash, he pointed to this case to emphasize that the present case is indeed a proprietary claim. As it was said in that case, that, quote, absent a proprietary claim, a defendant's assets belong to him, and a freezing order is not even intended to give a claimant security for what he alleges is due to him, end quote. The final case was State Bank of India and others against Dr. V.J. Mallya, that's M-A-L-L-Y-A, and others, open square brackets, 2020, close square brackets, capital E, capital W, capital H, capital C, 617, open square brackets, 11 closed square brackets, in which the court noted that, quote, transactions that are one-off or not ordinary require scrutiny from the court to make sure they are not being made for an improper purpose, closed quote. Next paragraph, it is not for me to decide on an ex parte basis whether or not the securitization is in Aria DMCC's ordinary course of business. I am, however, concerned about the complete lack of evidence about the ownership structures of the various assets purchased with monies remitted by FDT and legacy. I am concerned about the lack of any detail of the securitization process and the ambiguity of such evidence as has been adduced. I am concerned by the timing. There is no evidence as to why the securitization needs to be completed before the return date. I know that no third-party interests are involved. Mr. Holloway says that all that the claimant requests is holding the ring until the return date, and if there is good reason for the haste, the first respondent can apply to discharge the order. Weighing all of the foregoing in the balance, I consider that there is a serious issue to be tried as to whether or not the securitization process is being undertaken with undue haste before the return date in order to undermine or negate any order that may be made following that hearing. I consider that the balance of convenience favors holding the ring until the return date. There appears to me to be no reason why the securitization process should take place before the return date, and arguably good reasons why it should not. I consider that it is just and convenient that an order should be made. No third party is affected, and there is no evidence that the first respondent will be greatly hindered in its plans before the return date. I accept that the transaction is an unusual one, and it should have been appropriate for the first respondent to have obtained the court's approval before embarking upon the securitization process. I will therefore make an order restraining the first respondent from taking any steps in relation to the securitization process until after the return date or further order of the court. Now, Mr. Holloway, we have, I think, sent you a draft order which needs some amendment.
Yes. We have received that.
Let's just get that. Okay. I'm not going to go through the recitals. That can be sorted out. Let's just look at the order. The order is in slightly different terms than the one that I just mentioned in my judgment. What I said is that I would restrain the first defendants from taking any steps in relation to this securitization pending the until after the return date or further order of the court. I don't think it's necessary to refer to determination of an application to the court by Aria DMCC, as the next clause of the order gives the first respondent liberty to apply to vary or discharge. So I don't think that's necessary. Obviously, the costs are going to be reserved. You're going to have to include in that a transcript. I'm talking about 4 now. You have to include in 4 a transcript or a note of today's hearing and the transcript when it's available.
Yes, sorry. We're looking. We will include that in paragraph 4.
Yes.
Yes.
So will you clean this up?
Yes, of course, Your Honour. Thank you.
I included the penal notice.
Yes. And then Sorry, Your Honour, I didn't mean to interrupt you. If you're
No.
in terms of the service, Your Honour, if this order is issued today, we would like to serve it today for obvious reasons, and we would be able to get the note completed today. The affidavit may take a little longer, just because of the practicalities of having it done in Asia. So I'm just in Your Honour's hands, but we'd ask if we.
No, you can certainly serve it today, and I mean, what you can say, and you can add the words as soon as possible to 4.
Oh, I'm grateful, Your Honour, grateful. I mean, we've already ordered the transcript on a 24-hour basis, so we're hoping that the transcript would come tomorrow. If Your Honour wants us to serve the note today,
I do want you to serve the note today.
Okay, understood. Thank you.
Anything else on this?
Your Honour, no, not from our side.
Okay. There was just one outstanding matter. You had an application on the papers in relation to the banks.
Yes, Your Honour, yes.
I think I made it pretty clear on the last occasion that unless and until I make a final injunction, I'm not going to make an order against the banks. I know they've been served with the order, and I know there are onshore attachments which I have no jurisdiction over. But it seems to me that until I make a final order, if I do, and I did note the legal submissions in particular made by Mr. Montague-Smith on the last occasion, until I do make a final order, I'm not going to make an order specifically against the banks.
Could I take just a moment to take instructions on that, just in case there's something that someone wants me to say to you?
Yes, you can do.
But subject to that, I don't have anything else to say to you. So I'd be grateful if I could just.
Yeah, just do.
I think, I think we were hoping that this could be advanced against the banks with their consent, but I'm not going to press this further today. I think it's not appropriate, but it may perhaps come back to you in writing on that if so instructed.
Yeah, well, we'll leave that over.
I'm grateful. I'd just also like to say a word of thanks to yourself and to the registry for accommodating this so efficiently over the weekend.
Yes, particularly since we're actually closed this morning.
Yes, we noted that. We're very grateful.
Okay. Right. Well, anyway, I suspect I should be seeing this again pretty shortly.
Well,
okay. Well, thank you for your submissions. And I think that's probably it then, isn't it?
So we'll send the draft back.
Yes. Yeah, I do. Yes. Yeah. Oh, yes. Yeah. I need to approve the draft order.
Thank you very much, Your Honour. Thanks again.
Okay. Thank you. Good day.